Good morning, good evening. Thank you for joining us today. I am Angelita Bayens. I'm the Vice President of International Advocacy and Litigation at Robert and Ethel Kennedy Human Rights Center. It is with really great excitement that we are holding this webinar today and officially launching our new joint report on freedom of peaceful assembly, on litigation gaps and opportunities at the international and regional levels. Before I turn it to my colleague Nefeli Polopati, who's going to be our moderator today, I wanted to give you all a bit of background on this report that we're launching today. The Kennedy Human Rights Center has been working on the protection of civic space for many years, including through the use of strategic litigation at the regional level with the Inter-American system, the African system, and the UN as well. And as a core civic space right, we were interested in identifying the areas where freedom of assembly could use further legal development through the jurisprudence of these regional bodies and at the UN level, and as a way to inform our future work. So especially because, the world had been seeing and has been seeing a surge on especially protests, social protests, but also very strong crackdown on those protests. So with this objective in mind, we partnered with the Center for Law and Democracy and with Toby Mendel, who's going to be speaking today, to work on what initially was intended as a more internal document to inform our work at the center. But when the report was finished, we thought it could really become a very useful tool for other litigants, for other civil society organizations, and really for anyone who's interested on the topic of freedom of assembly. So here we are today. We are very excited to share this new tool, and we hope it's helpful and useful to many people. And we're particularly happy to be launching it in such a great company with some of the biggest experts around the world on freedom of assembly. So thank you again for joining us today. We hope you enjoy this conversation we're going to be having. And if you cannot stay for the whole webinar, we're going to be recording it, and it will be available on our YouTube channel. So without further ado, I'm going to turn to my colleague Nefeli to kick off the webinar.
Thank you very much. Thank you, Angelita. Good morning, everyone, and thank you for joining us today. I'm Nefeli Pulapati, Civic Space Legal Fellow in the International Advocacy and Litigation team at the Robert and Ethel Kennedy Human Rights Center, and I will be your moderator today. Please join me now in welcoming our first speaker, Toby Mendel, Executive Director of the Center for Law and Democracy. Toby is the lead author of this report, and he will be providing a comprehensive summary of the main findings of our joint report. The floor is yours, Toby.
Great. Well, thank you very much. And thank you, everyone, for coming. I know there are a million online things to attend and very easy to attend them, but then there's too many of them. So we appreciate your focus on us, and we hope you find the discussion useful. So, I mean, as Angelita said, the main aim of the report really is to support different actors, mostly civil society organizations, but also academics and others, in planning their research and litigation strategy around freedom of assembly or freedom of peaceful assembly. Our goal was to identify where are the gaps in the jurisprudence, because probably people want to focus on where those gaps are and filling the gaps rather than just reiterating established standards. Although there may be cases where standards have been set out by international jurisdictions which people don't feel are the right standards or are sufficiently progressive standards, so there may be a need in those cases to challenge those standards. Of course, behind that, again, as Angelita hinted at, I mean, there was a recognition that the jurisprudence on peaceful assembly is really limited. And I mean, especially if you compare it to the jurisprudence on freedom of expression, which is a huge and developed body of jurisprudence, but even freedom of association, that we really notice that there's a lot less in the assembly space. And I mean, I don't think I need to elaborate to this audience and today how important freedom of assembly is. And just to give one tragic example, the events that have been unfolding in Iran over the last few weeks. I mean, I think, everybody is seeing that, on their, I was going to say their TV screens. I'm an old-fashioned guy. I still watch the TV, but on whatever news sources they use, we see a challenge of the regime coming through assembly and blatant disregard for that freedom by the regime. We knew the jurisprudence was limited, but when we really dug down into the research, I think that really reinforced how limited the jurisprudence is. Ultimately, at the time we closed the research, we only found 49 cases in the target jurisdictions, and those jurisdictions are the UN Human Rights Committee, the African Commission and Court on Human and People's Rights, two sub-regional courts in Africa, and the Inter-American Commission and Court of Human Rights. So, and not the European Court of Human Rights, although we researched the jurisprudence there, but that was not our target jurisdictions. So among the target jurisdictions, the areas where we thought the groups might be interested in filling gaps, we only found 49 cases. But even that small number of cases exaggerates the paucity of the standards, because 33 of those cases are before the UN Human Rights Committee, and almost all of those cases just focus on one issue: notification regimes. That you have to notify the authorities before you have a demonstration or an event, an assembly. So that's just one very small issue from among the wide range of freedom of assembly issues. And many of the other cases raised multiple human rights issues. So freedom of assembly was one issue, but then they might have had, a number of others. In one case, for example, we found 9 separate human rights claims, and quite often the courts would focus far more on some of the other claims and only give brief treatment to freedom of assembly. So the 49 cases, even though that's very small, still didn't really provide a lot of elaboration of standards. So the overall picture is that instead of a robust lattice work of standards, really we have a framework of gaps more so. And so, of course, for those considering engaging in litigation in this space, the key issue will be what to prioritize, because there's so much choice, if you will, in terms of the gaps that need to be filled. I'll just say a few words about the methodology so people can understand that. I mean, if you want to identify gaps, you need to start by understanding what a full framework of standards would look like, and then sort of see where the jurisprudence has weighed in and where it hasn't. So we started assessing that by looking at the more complete jurisdictions, the more fulsome jurisdictions, specifically the European Court of Human Rights, as well, of course, as the target jurisdictions. But even with that, we still found there were a lot of gaps, standards, areas where there needed to be standards where there wasn't. So to fill that out, we looked at the guides on freedom of expression, freedom of assembly, and we were very fortunate to find quite a rich vein of material in that space, including, for example, standard setting by the European Court of Human Rights, by the Venice Commission, a general comment by the UN Human Rights Committee, and reports by both the Inter-American and African human rights systems. So quite a lot of authoritative statements on what the standard should be. And with that and the jurisprudence, we were able to piece together a pretty full picture of what the standard should be. And we developed from that what we called the classification guide, which essentially served as the table of contents for the key part of the report, which is the overview of gaps. So we organized the standards into a bunch of sections, if you will, and subsections, and then kind of slotted the jurisprudence into that, so we could see where the jurisprudence had established standards and where it hadn't. So I'm going to move now to talk about the substance of our findings. As I mentioned before, there's a lot of gaps. I'm certainly not going to go through all of those because that would take up the whole hour and a half. And I know all of you are going to read this report with great interest, so you'll get the full picture that way. I'm just going to highlight what we felt were some of the more important and perhaps interesting areas. First, the scope of the right. It's clear that you can have an assembly which is advocating for law reform. So you're saying the laws are wrong, they need to change, even to change the Constitution. That's perfectly legitimate. It wasn't clear to us whether an assembly which sought to convey a message which was prohibited under the scope of freedom of expression, for example, an assembly which advocated for hate speech, whether something like that would be allowed or not allowed. The jurisprudence doesn't touch that issue. A little bit academic, perhaps, because we don't see that too much, but we thought it was kind of interesting. At some point, assemblies lose their protected characteristic because they become too violent. So, the protection is for peaceful assemblies, and it's clear that a little bit of disruption, pushing and shoving is normal in assemblies, and that doesn't lose their character, their protected character. A little bit of violence by some participants, again, will not render the whole assembly, unprotected, but at some point that does become the case. The jurisprudence is not very clear on that issue. In terms of activities that are undertaken during assemblies, it's clear that violence and destruction of property are not protected activities within assemblies. On the other hand, freedom of assembly is an interesting right in as much as it specifically protects breaches of the law. For example, jaywalking or disturbing the peace by making noise. What the European Court of Human Rights calls non-reprehensible breaches. That's their consistent term for this. You're allowed to break the law when conducting an assembly, but you can't commit violence. Where in between those two, standards does activity become unprotected? Again, something the jurisprudence hasn't clarified very well, and which seems an interesting thing to us. It's also clear that states and indeed citizens need to tolerate a degree of disruption from assemblies. So assemblies take place on the street and you can't drive down the street. They may block access to Parliament, where maybe you work in Parliament or things like that. You need to tolerate that disruption. But at some point, that disruption becomes disproportionate. You have had an opportunity to make your point within sight and sound of your targets. That's a key value of freedom of assembly. And at some point, you've done that, and the disruption becomes, excessive. And at what point is that balance struck? I am based in Canada, and we had a very dramatic example of that in our country, which many of you may have heard about. We had truckers occupy the downtown part of Ottawa around the Parliament building, big 18-wheeler trucks, and they were there for 3 weeks. They were blowing their horns, they were blocking things, and eventually they were removed. And I think, it was clear that at that point they had become unduly disruptive and they made their point. But, in between sort of a short period and a long period, where does that come up? Notification regimes, so a requirement to notify the authorities, can facilitate freedom of assembly because it can help the authorities provide facilitation to assemblies. For example, they can reroute traffic while you go down the street. They can provide security, medical support, those kinds of supportive features. So it's, in a way, a pro-freedom of assembly system. But we also saw a lot in the jurisprudence of cases where notification regimes were used abusively to prevent assemblies, to deny people the right to assemble. So where between those two, extremes, if you will, or what are the key features of notification regimes which will support their facilitatory characteristic, but not allow them to become abusive? Just a couple more, if I may. At some point, the use of force may become necessary when an assembly becomes violent or otherwise needs to be removed. For example, in Ottawa, the disruption became unbalanced and the truckers excuse me, needed to be removed. So we very little detail really in the jurisprudence about when that ability to use force is triggered, and how far you should pursue non-violent measures, warnings, and sort of okay, that's enough, you need to go, and whatever, and what are the rules on the ratcheting up of force. So certain forms of force like live ammunition should never be used to disperse an assembly, for example. So what forms of force are permitted? And then finally, the whole issue of private actors' responsibilities vis-a-vis assemblies. And it's clear certain, non-intrusive the private sector obligations are present, but for example, do private actors like shopping malls or private roads have an obligation to allow assemblies to take place on that private property, an issue that's just touched on in the jurisprudence. So I'll stop with that initial set of comments, and over to you, Nefeli.
Great. Thank you so much, Toby, for walking us through the report that we launched last week. A key part of the report addresses strategic considerations for those considering engaging in strategic litigation on freedom of assembly. So what are the main issues canvassed in this part of the report?
Yes, thank you. So we, as I said before, the main part of the report, highlights the gaps, but we also wanted to provide some strategic thinking to those wishing to engage in this area. And I mean, the first question I really think people need to think through is, I mean, what is your goal? Are you trying to develop general standards in this area, or you have a focus on a particular jurisdiction? And of course, that a lot of factors may go into that. Obviously, the Human Rights Committee, there are 175, states parties to the ICCPR, so it's the scope of its jurisprudence is much broader, the global impact, and there are quite a few countries for which it's the only international system. So countries outside of Europe, the Americas, and Africa, so Asia and the Pacific, that's their only human rights system. But I would say it's significantly more challenging, especially to intervene in cases at the UN Human Rights Committee. They have a complete list of pending cases, but there's only like a one-liner on those cases, so you can't identify what the specific issues are. In contrast to that, it's a lot easier to intervene at the African and inter-American systems. And I would say there's also within those regions, there's quite a significant power of the courts to spread their jurisprudence. And for example, a regional court, the African Court on Human and People's Rights came up with a very strong ruling on criminal defamation, ruling out criminal defamation as a restriction on freedom of expression. And I mean, it traveled, regional, the sub-regional courts picked it up, and a lot of national courts picked it up. So that kind of impact beyond the case in the region, and you certainly see that phenomenon also in the Americas. And I would say that especially the inter-American system has demonstrated more willingness to be expansive in its approach, certainly in the area of remedies, but also in terms of setting substantive standards. So you don't get a lot of opportunities to get before these courts with your cases. If they just stick narrowly on the facts of the case, your standard setting role is going to be limited to that. If they're willing to go a bit further, and the inter-American system particularly, but also the African system a little bit so. Some issues are very fact-based, so that when you get a decision, unless the court is prepared to be expansive and set out, complete factors relating to that issue, which, I mean, you have to be lucky with that, you're just resolving the standards in that fact pattern. So for example, I talked about accommodation of disruption. The Ottawa protests were a very specific and unique example. An international decision just focusing on that, might tell you whether big trucks can occupy a capital city for more than 3 weeks, but they're not going to really set out standards on what you need to tolerate in terms of disruption more generally. So there's quite a few. So if you are, but we still need standards in those areas, and many of the issues issues I highlighted where we need, particularly need standards are very fact-based. So again, approaching jurisdictions which may be a little bit more expansive, may be willing to set out a more complete set of factors rather than just deciding the case before them. I would also note some issues are hard to reach through litigation. For example, the issue of positive state obligations. So states are supposed to put in place in advance of, or to deal with ongoing assemblies, they're supposed to put in place frameworks. And I mean, those are things that are supposed to happen before the assembly, but the facts of the case often rests on what happened during a specific assembly, which was denied or disrupted or whatever. Hard to get at the positive obligations. So again, we need to think a little bit about that, and the more expansive jurisdictions may be better for that. And then finally, the issue that I mentioned before, almost always these cases involve a panoply of human rights breaches. Often there's an excessive use of force or a denial of freedom of expression, or often many other rights. It's been difficult to get courts in many cases to concentrate on the freedom of assembly part of it, because sometimes the other parts of it are more obvious, more dramatic. Somebody was killed, somebody was injured. So how to kind of get courts to focus on the core freedom of assembly issues, and we have some strategies in the report on that. I'll stop with that. Thank you.
Great. Thank you, Toby. We hope that everyone joining us today and those who will watch the webinar later too will feel motivated and curious to check out the report if they haven't already, and incorporate it into their toolbox as they continue to work towards stronger protections of the right to freedom of assembly. To take us further in today's webinar, we have the honor of inviting 3 distinguished experts to discuss the key gaps and opportunities in the jurisprudence on the freedom of assembly within the international and regional human rights systems covered by the report. First, we'll hear from Gina Romero, UN Special Rapporteur on freedom of peaceful assembly and of association, who will share her perspective with particular focus on the UN system. You can find Gina's full bio in the chat. And Gina, the floor is yours.
Thanks. Thank you, everybody. Can you hear me?
Yeah.
Okay, perfect. So first of all, thanks for the invitation. I'm pleased to share panel with admired colleagues and friends. I'm really, really glad to be here. Let me start by saying that I actually congratulate the Robert F. Kennedy Human Rights and the Center of Law and Democracy for such an interesting and valuable effort. I actually enjoyed very much reading the report, and also sparked several ideas and reflections, some of which I want to share with you today. I don't have time to comment on all the things that sparked, but then just at least I'll try to pin on some of those. So first of all, regarding to the work I do as a special rapporteur, I believe that most of the assembly-related challenges that I've encountered in my work are included in the analysis of the report. I want to praise the inclusion of the guaranteeing of an enabling legal framework, as the adoption of the restrictive laws and regulations against collective citizen action, including protest, is one of the more increasing trends I have been reporting worldwide. So in this specific issue, it is very important to see how the internal litigation is key to hold government accountable on ill-intended legislation adopted, such as, for example, the Protocolo Antipiquetes in Argentina that was just declared unconstitutional in a court review some weeks ago, thanks to civil society organizations litigation. But also this review on the legal framework also need to go beyond the specific laws, protocols, and processes that are related to assemblies, especially protests, to actually be wider and including other laws that also affect the right to protest, even if it doesn't seem like that when you see the other laws from just a perspective of non-thinking on protest. And just to put an example, in my official visit to Chile last year, I identified over 10 laws, bills, protocols then deeply affect the exercise of the right of a freedom of assembly, and also affect and create obstacles to ensuring accountability, justice, and reparation for human rights violations in the context of protest. So these also need to be taken into account, especially as we have now a wave of amendments of penal codes, for example, worldwide, that is constraining the right of freedom of assembly. A huge challenge that I am glad that it was included in the report is about the context of violence, as Tommy was mentioning, and then this very fine line when protests stop being a peaceful protest and start being something else. And here I could talk a whole hour about this, but we need especially much more analysis and developments. And as in some cases, violence is defined to lose. So, for example, the destruction of property. What is the destruction of property? So, is breaking a window destruction of property? So, the Attorney General in Colombia, for example, have an approach on this that could be interesting to review. I don't have time to go deeper on that, but this is something for the future. Also, I'm really glad that the report includes mention on how minor criminal acts and contraventions need also to be tolerating. When I talk to people who is mobilizing, because I observe assemblies, I always encourage them not to break any law. But in some cases, walking the street or standing in front of a protected infrastructure, or gluing yourself in the floor, or using a kefille, or chanting in a language different to the country's language, or dressing as a Pikachu, and other issues is considered a criminal offense. So this is not easy, it's very tricky. So perhaps also Michelle's forced guidelines on civil disobedience and peaceful environment protest could be also useful to actually put more meat on what does it mean to actually just breaking certain minor laws. Also related to the use of violence, the huge challenges for me is to identify how and why violence starts in protests that are completely peaceful. And there, the role of provocation by law enforcement itself, by unidentified individuals and groups, and other possible agent provocateurs. I'm also glad the report make an emphasis on the use of force by the police. I just don't have time to go deeply on all the issues related to the use of force. But then I truly believe that the toolkit for law enforcement officials that my predecessor produced can also spark some interesting views on how to do cases on litigation. But also I will recommend to talk about law enforcement agencies, not only the police, because the police respond to politics and administrative powers, and therefore the litigation process need also to follow the full command chain. And also, I think we have a responsibility to tackle the killings of protesters, as Toby were mentioned, as just even when an assembly is no longer considered peaceful, restrictions and the restrictions on this person apply, then the participants remain in the use of the other rights, including the right of life. I also think that in all this use of when we are talking about the lethal weapons, the law enforcement agencies, we need to make more emphasis in the proportionality. We have the case now in Chile, for example, with Gustavo Gatica, that was blinded by the police using less lethal weapons because he was throwing stones to the police. That's the allegation. So one stone versus kinetic impact in his eyes. I don't know. The proportionality is something that needs to be more brought into attention, and I think that and this disproportionate effects are happening repeatedly worldwide. I'm also for sure glad that the issues of accountability or redress are included, but then we need a lot more on the guarantees of non-recurrence, and perhaps more specific cases can identify about this. And then also, in my last minute on this part, it's important to actually try to unpack the rights to officials to participate in protests. But then I have an extension to this, is that when public officials, including presidents, call for protest against the action of the result of the action of Congress, the action of the result of actions of Congresses and courts. And this is relevant to analyze, especially if workers in the public sector receive these sort of invitations to these protests. So are they allowed not to participate? I don't know. This is also something that is very tricky and that we perhaps can just check. And then also about the private actors, I have been having several discussions due to the pro-Palestine solidarity movement assemblies, that have been happening in the universities that are either private or are public but located in private property. So there are a lot of unpack there, and some interesting cases can be used to litigation. I have many other issues about gaps and challenges. I don't know if I'll have time later on, but then it is very important to talk about the stigmatization and the harm that hostile narratives do in the exercise of the right, and also the chilling effect. I know that proving the chilling effect is very difficult, but then I think we need to try to figure out how to do it. And then I also have some comments about the misuse of technology that I didn't see in the report, and also the challenges that are already included in the report. We need to actually analyze in situations in which these challenges skyrocket. For example, in elections, in the state of emergency, and conflict-related context. And also some issues about the so-called less lethal weapons that I can perhaps talk in another moment. Thank you.
Thank you, Gina, for sharing your experience and insights with us today. Now we'll be hearing from our next panelist, Pedro Vaca Villarreal, IACHR Special Rapporteur for Freedom of Expression, who will discuss the gaps and opportunities in the Inter-American human rights system regarding freedom of assembly. You can find Pedro's full bio in the chat. And Pedro, the floor is yours.
Thank you, Nepali. And I would like to start by thanking this report. I think that this report led by the Kennedy Human Rights Center, I congratulate and thank the people that is behind this, all the people that is behind this report. My first thought is that it's an outstanding report. It is detailed, it is practical, it is very well curated, it's organized. And when I put these labels on the report, it's not a cosmetic approach. I think it's in our work, we have to read a lot of reports, and I highly encourage, stakeholders to be inspired in this report because I think it is unique. I think this report collects with an expert view what has been done worldwide. In my very personal experience, 5 years at the Inter-American Commission, I also felt constructively uncomfortable. And I want to express this as a good feeling because the report shows things that I haven't seen in my work, and also shares what has happened in other regions that could be also relevant for our work. So this is my first reaction to this report. I hope this could be useful for the stakeholders that follow freedom of assembly, because this report also happens at a very unique moment of this right in the world, because we are not only monitoring repression in non-democratic states, but also in democratic states. So I think it's important to have this in consideration. I like how the report asks for a clear rules on the use of force, for example, and more precise understanding the state obligations to facilitate and protect assemblies, and also what's the difference between permissible legal restrictions and forbidden authorization regimes. In my view, what I see in the region I follow, I think there are two big or central discussions on the right to protest. And the first one is related to the use of force, and I think the report touches deeply that topic. From what I've seen, the use of force in the hemisphere, in some contexts, continues to be lethal and involves firearms. So when I say practical, I hope this report could save lives in the future, because we have monitored how the lack of a proper implementation of international standard has opened the space for impunity and lethal violence. And the second trend or concern we look at in the region is the criminal prosecution that often follows protest. The punishment sometimes using criminal law. So I think those two factors are very relevant to be considered, because the when I look, for example, at our standards, our three-part test, necessity, proportionality, legality, I think it's important. I think those principles and requirements, criteria are well rooted at the inter-American system. But the report you are sharing also ask uncomfortable questions on how how, how hard it's to implement those criteria in very concrete cases, and that's where the case law provides different approaches. And when you collect it, I think it's a very integrated perspective of what is happening now with the right for freedom of assembly. Uh, Also, I think that when we uh, consider the right to protest, there are other challenges now, since, for example, the judicial proceedings are open. I mean, on the basis of such offenses, a key challenge moving forward is to clarify the distinction between a protest and an insurrection, and between protected expression and unprotected speech. Across the region, authorities increasingly invoke concepts as democracy or peace or security to justify restrictions on peaceful assemblies. And I think those dilemmas between insurrection and protest, and protected speech and unprotected speech, it's something that we have to solve in a way, because it's a gray area that could be displayed against the right to freedom of assembly and expression. These are restrictions these restrictions often affect groups in situation of vulnerability, for whom public demonstrations remain one of the few effective channels to be heard. In my view, ensuring protection of these voices is essential, and the Inter-American Commission of Human Rights has begun admitting cases involving subsequent liability, which may create a space to advance this discussion. So I think that this report collects, but also provides a path forward, where stakeholders that follow freedom of assembly and association could be inspired, and also with the commitment that the work you've done is well backed by a research and a methodology that is really important for our work. So thank you again, and happy to be here with you.
Thank you so much, Pedro, for these thoughtful reflections and concrete insights. We will now turn to our final panelist for today, Donald Dea, Chief Executive Officer of the Pan-African Lawyers Union, who will discuss key gaps and opportunities in the African system regarding the right to freedom of assembly. You can find Don's bio in the chat, and Don, the floor is yours.
Thank you very much, Nefeli. And let me begin really by thanking the Robert and Ethel Kennedy Human Rights Center, also on your rebranding, and also the Center for Law and Democracy for the research, for this wonderful publication, and also for this webinar. I'd also like to thank you for finding time, Gina Romero, and also Pedro Vaca, for finding time to actually join us as we have this conversation. The report itself, and even the way Toby has summarized it, is already so complete. You find it hard to find anything new to say. It's like we'll more or less be repeating in different words what Toby has already said. In the context of the African continent, the 55 countries and the 5 regions of continental Africa, of course, we have the African Charter on Human and People's Rights, which articulates in broad strokes the rights to freedom of peaceful assembly and association. We do have 2 sets of soft law from the African Commission on Human and People's Rights, the Guidelines on Freedom of Assembly and Association in Africa of 2017, and also the Guidelines for the Policing of Assemblies by Law Enforcement Officials in Africa. And indeed, of course, most national constitutions also have the provisions in broad strokes. But just like in other parts of the world that we have adverted to, there is no coherent body of jurisprudence that explains this right in great detail. As has been seen elsewhere, freedom of assembly tends to be overwhelmed by and buried deep beneath other rights. Most of the decisions you'll get, whether it's at national level or at our regional and continental level, the African Court, the African Commission, the ECOWAS Court, the Court for West Africa, and the East African Court of Justice, most of the decisions will mention it very briefly, and it's usually buried under the freedom of expression, freedom of political participation, the right to information, the right against mass violence, especially with these Gen Z protests we've been seeing, or public order. And when I was just reflecting, a decade ago, when Maina Kiai was sitting where Gina Romero sits now as UN Special Rapporteur on the rights to freedom of peaceful assembly and of association, we formed a team that did its amicus curiae interventions in a range of national and international courts. But reflecting back, many of them were actually more on freedom of association, the rights of NGOs to exist, sometimes political parties and so on, such as the case we did for him at the AFCON court, which concerned the Rwandan NGO Liprodo. So we do find that our courts have not clearly articulated what states must do or not, and especially what to do to facilitate assemblies. And like Gina says, what kinds of restrictions are permissible or impermissible. And one of the damaging gaps that we find is around that area, which Gina also spoke about, is when an assembly ceases to be peaceful, and especially who caused the lack of the peace. Because what we've seen in many of the African countries is even when there's one set of people carrying a peaceful assembly, they'll be, infiltrated, by other actors, many of whom, have been hired maybe by political parties or sometimes even by the police themselves. And the cause of the violence or the cause of the crime is actually emanating from these few elements who have infiltrated. One can look at the ECOWAS court case in Sarah versus Nigeria. Again, well, the court engaged extensively with the issue of excessive force and freedom of expression during the Nigerian NSAS protests. It did not clarify whether isolated violence justified a dispersal and what is the evidentiary threshold for that. That, of course, leaves states to continue relying on public order narratives, while leaving the protection and especially promotion of the right to freedom of assembly not addressed. And these all issues, what are the state obligations? I think, Gina, you've also talked about it, is a question that is left out. What are the positive obligations of states? What must they do in advance to facilitate assembly and to provide rules, regulation, guidelines that facilitate assemblies and protect those who are assembling from third-party violence or crime? So that's also an issue that remains quite unaddressed. Let me stop there for now.
Great. Thank you very much, Don, for sharing these valuable insights. We will now be opening up the conversation to all of the panelists, so please all feel free to chime in to address the next question. So taking into account the previous discussion, do you feel that we need to aim for a more coordinated strategy globally and in the different regions of the world on this issue? Or is it better to just provide the guidance and let everyone do what they think is best?
Who's that?
Is that for us, right? For all of us?
Yes, for all of you. Feel free to chime in.
Thank you. I just to say something that could be like very simple, but perhaps is useful to say, is sometimes the issues that happen around protest are actually like difficult to analyze. Sometimes I call, and I'm sorry, Pedro, if I'm overstepping, but sometimes I call Pedro and say, what the hell are we going to do with this? Because it's difficult. Sometimes the reality, it's just completely, the standard, right? So the standard here, the reality is here. How can we push put them all together, that is not easy. So perhaps we could actually benefit for talking more about among ourselves in analyzing certain specific issues that I think that will need more attention from, for example, my mandate, and how does that attention can be actually implemented. And sometimes the challenges are very similar and our agendas are aligned. So, for example, Pedro released a report very recently, like December last year, I think, or November, about the use of technology and how that is affecting the right of freedom of expression in Latin America. And then my report to the Human Rights Council next year is similar. So actually, we had the possibility to be together in a consultation that I did for the Latin American actors to actually go deeper in this. So yes, we do need to work more together, not only in doing the processes. I mean, I've been doing amicus to several of the cases, especially in Latin America, but then also just to go deeper in analyzing the different issues. One specific point that I want to mention about this, and this is something that I really would like some help, it's what happens, and this is also included, at least mentioned in the report, and it is I also thought about that when reading the report. It's what happened with the assemblies that are not political or expressive, although I believe that all assemblies are expressive, the use of expression of the people, that are cultural assemblies. So, for example, I have a lot of things to think about the use of technology in, for example, the carnival. An example, a very concrete example, the Brazilian carnival in Sao Paulo, to actually target certain people that have committed criminal offenses and need to be taken or seized or are seized by the police in when they are participating in carnival using facial recognition technologies and so on. So what do we do with those cases? I mean, it is also an assembly, but it is an assembly that is a cultural assembly, but it's also trying to the law enforcement is also trying to do a lot on fighting crime. So those issues, sometimes the reality just exceed our capacity to analyze the implementation of the standards. So this is where I think that it is good if we come together.
Did anyone else want to chime in on this question? Otherwise, we can move on to the next one as well.
There are two hands up, Pedro and Toby.
Oh, great. Pedro, do you want to go ahead?
Please, Toby, go ahead. You raise the hands first. It's okay.
Okay.
Well, I'm not sure about that, but anyway, I think we have time. Yeah, I mean, I thought that was very interesting, Gina. I mean, the focus of the report is on litigation because it has quite a specific focus. But you actually raise what I would say a much broader issue around collaboration, which perhaps I would broadly characterize as the idea of engaging in sort of deeper collaboration to understand the standards and complex fact patterns. Oh, I'm sorry about that. I'm just going to let that run. Fact patterns around assemblies. I've done a lot more work on freedom of expression than I have on freedom of assembly. And, regularly we bring together leading actors, civil society and official but independent like yourselves, and to discuss, okay, what about the hard cases and about, what are the cutting edge issues and what's next and all that, sort of, so that we're deepening our understanding of this right. We're forging sometimes more effective collaborative strategies on the hard issues. I mean, there's a package of issues there where we have fora where we discuss these things and we collaborate. And perhaps that's not yet advanced so much on the issue of freedom of assembly, just like the jurisprudence isn't much advanced, but it goes well beyond just a litigation strategy. It's an understanding and advocacy and collaboration strategy. And I mean, not to build too much on this one webinar, but maybe we should, move forward and bring together some of the leading actors and have some, not in an open webinar where we're talking to the world, as it were, but where we're just sitting down ourselves and, with the right people, and, that we can have a discussion about that and do that. I think that, sounds to me like that might be quite useful. I don't know whether you would agree with that.
Probably I can go on very, very, very short. I think that coordination, it's a good desire. I think it has its own practical challenges in the current days. No, I think that coordination, for example, among civil society that look for justice, it's important. So if we look at I mean, previous 5 to 10 years, the lethal violence in the Americas, and the groups of victims and litigators are very well coordinated, and I think that it's good for them to seek justice and reparations. But I would prefer another concept, and it's coherence. I think we need coherence in the international standards on freedom of assembly. Why? Because, for example, when we talk about law enforcement, we have international cooperation in security. So it would be very important for democratic countries that provide law enforcement assistance to put layers in the recipients of that assistance, in the good use of that security cooperation. It would be very important for international community multilateralism that, I mean, and there I include the office I'm in charge of, to put some kind of coherence to what is happening. Because sometimes my feeling is that the protection of this right depends on the country, on the message, and I think those lines and borders are very risky. So I think that coherence, to look for coherence and an integrated conversation, and I think that's where this report plays a significant role, because anyone that reads it carefully will find, I mean, very strong statements, and I mean, the gaps you identified are very well defined. And I think that also could imply a better coherence of the system.
Thank you very much, Toby and Pedro. Dawn, is there something else you would like to add to this? Okay, great. Well, then we will be turning to the audience for any questions. I think there has been one which Toby already answered, so thank you very much, Toby, for that. So yes, please feel free to add any questions to the Q&A function here on Zoom.
Maybe while we're waiting for that, one other point I'd like to make, that kind of bouncing off what Pedro said. I mean, there is sort of the jurisprudence is maybe the size or the strength or the weakness of the jurisprudence, maybe the tip of the iceberg, and underneath that there's a whole bunch of other things. So, for example, if we look at the freedom of expression world, historically at least, and of course the funding situation globally is very tough right now, with essentially the withdrawal of the United States, from that space. But there has historically been not enough, but still a reasonably significant amount of funding flowing to freedom of expression in all kinds of ways, including support for media actors, but also support for research and litigation and all that kind of stuff. And probably there's much less of that in the freedom of assembly, and perhaps also, I mean, I would say that sort of freedom of expression is probably the top association next, and assembly at the bottom in this kind of weird hierarchy of rights in terms of attention and focus. So maybe when I was bouncing off Gina's comment and said, maybe we just need to come together as people who are interested in this and talk about all of the issues. Maybe that's another one, is how to, attract more global attention. And I think we are in unfortunately, but maybe we can use that to our advantage. We're in a good moment for that, because we are seeing some very, very high profile assemblies around the world, which have, undoubtedly, strong democratic and positive goals, and yet which are being, grossly and brutally repressed. Obviously, Iran, the most obvious and brutal case of that, 3,000, minimum 3,000 people, probably much more than that, killed. So maybe it's a good time to have that conversation as well.
Great. Thank you, Toby. We also have some individualized questions that we would like to address to each of you. So perhaps, Gina, starting with you, how do you envision the role of Special Rapporteur in shaping the future direction of international standards on freedom of peaceful assembly, particularly in areas not yet covered by the Human Rights Committee?
Well, I mean, you all know that our capacities is very limited, but also the real possibility for us to, I mean, it's not the same a report that I do that, for example, the general comments that the committee provide, or even the review of cases. But for example, specifically on some of these specific topics, I was going to mention. I just didn't have time. That I'm preparing a report for the Human Rights Council on the use of technology, technologically mediated surveillance, that it has a strong emphasis on the chilling effect. And I hope that this is actually very, it could be useful to spark some internal litigation that then can come also to the regional system. And then perhaps these reports are, and also that is going to talk also with Pedro's report, would also create some of these, like spark some of some knowledge and understanding from people that some things that are happening in for example the use of surveillance is not good, and it's affecting the exercise of the right, because now everybody is more like okay, yes, there is a camera, there are cameras everywhere, that's normal because it's just trying to protect us, and then just actually just creates this sense of normality in the surveillance that is actually not good, because that actually affects deeply the exercise of rights, specifically for certain groups that are vulnerable and then have been neglected in the rights in the past. So that is something that I am committed to do, and then once the report is presented, perhaps we can figure out with civil society and with other actors in how to bring some cases also for litigation or other more soft, if possible, advocacy actions. So that is from one side. From the other side, I am always thinking, and then this is what something that Donald said, but also what Pedro was saying about coherence. I'm always thinking, what's the role of the UN? And then you know that I'm not the UN, right? But then yeah, that always, yeah, I need to repeat this constantly. But also for me, it has been very distressing, and I'm telling this lively, but I've also said that to some of the Office of the High Commissioner folks, that then I still see some of the of very problematic use of force, especially lethal force, in countries that had received training and a lot of actions by the Office of the High Commissioner. So I keep telling them, how are you analyzing the success of this, and how can we actually do more? For example, the mandate has provided this practical guidance for the law enforcement in the context of protest, that actually has an annex on the use of technology. So why can we actually use this more with the support of civil society, with the support of other actors, just to try to also analyze what has been happening in the training processes of certain law enforcement agencies that actually are not are not delivering. And then we need to do that in order to figure out the future actions of training, for example. That is something that the report repeats, and I fully agree. So perhaps my role there is also trying to bring those gaps, and also to bring people together, which is something that I try to do. I can think on those two, but then this is a bigger challenge.
Understood, Gina. Thank you so much. This has been very insightful. Moving
Yes,
on
can I
to,
respond to that?
sorry, Toby.
Can I just respond a little bit to that?
Sure.
I mean, this is the interactive part, right?
Yeah.
I mean, thanks, Gina. And I mean, I think it's interesting. As soon as you said tech, I sort of thought, oh gosh, how did we miss that one? So you know, that I think that is you know, this whole session is about gaps. That's a gap in our report, which otherwise seemed to have been fairly comprehensive. But I think you know, I'm not quite sure. Maybe it's because I'm an older guy and I don't think about tech enough. But you know, I don't even like tech. You know, I'm just forced to use it. Well, not just joking. But I mean, I think that is an area where we do need, obviously, to focus more attention. And you know, it is going to be, I mean, you know, there's tech, and then there's tech on steroids, which is what AI is going to deliver us. And we're only, you know, we're only taking the first few steroid pills so far. As we go on and on, it's going to get more and more, you know. And of course, I'm not anti-AI. It can be, you know, put to good use, and including for human rights purposes, but it can also certainly be used the other way. I just a couple of points. I mean, I think with the training, and I mean, I have also done some work on training of police, and you know, developing manuals to train police and training police in the area of freedom of expression. So in the way that they interact with journalists. So it's a little bit analogous, I would say, to how they interact with assemblies, except assemblies are much more dynamic and on the ground. But I mean, but those trainings also have not infrequently, I would say, failed to meet their mark, failed to deliver what we had hoped for. And to be honest, I think an important part of that is the wider context. You cannot take somebody who sits in a police force whose whole whole world environment, or at least professional environment, is to sit in a police force which regularly and periodically abuses human rights in all kinds of ways, and you know, responds to a command structure that is not infused with human rights values, and that sort of thing. And you cannot expect a training to turn that around. I think that, you know, we need to you know, we need real culture change within those institutions, and training is an important part of that, but it's absolutely not a sufficient condition for that. That kind of my feeling on that. I just want to also make a quick comment on the issue of expressive purposes, and you know, mentioned about cultural assemblies. For me, a cultural assembly is absolutely has an expressive purpose. It's not a political, or you know, it's not, well, it might even be. I mean, a lot of culture is political too, but I mean, it might not be political in nature, but that doesn't mean it's not expressive in nature. You know, almost always culture is expressive. I mean, people, you know, communicate through culture and things like that. And so, I mean, I think that there was a question in the report, which maybe is a little bit more of an academic question than some of the very practical things we're looking at now, about whether a truly non-expressive assembly, like, for example, you know, people waiting in line to get into a sports event, or to wait for a bus or something, you know, whether that would be a protected assembly. I mean, I don't think it's very serious from an activist point of view, because, you know, usually the authorities don't attack those assemblies or those gatherings, so it's not something that we need to worry so much about the protection. And if I could just, Leandro Rebello has posted something in the questions. Can I just respond quickly to that? So he's asking, and Pedro, maybe you'd like to respond on this too, because I kind of pricked up my ears when you said, what, you know, insurrections and protests. And for me, I mean, you know, protests and, you know, as I said at the very beginning of my comments, sometimes we talk about peaceful assembly. or sometimes it's just freedom of assembly or freedom of peaceful assembly, and that is the dividing line. So, I mean, there's a lot of difficult questions which others have raised very well about, when does an assembly lose its peaceful character? What if there are provocateurs? And whereas the main assembly is, peaceful and has full peaceful attention, people who are opposed to the assembly then kind of come in and start disrupting it through violence and that kind of stuff. A lot of interesting questions there. But for example, the question talks about anarchists, and I mean, an anarchist assembly is absolutely a protected assembly, and being an anarchist is a protected belief and expressively protected, and everything protected about that. But if anarchists start using weapons and return to violence like anyone else who uses violence, then they're no longer protected. So for me, the way to navigate that issue and an insurrection, for me, automatically involves violence. You're not committing an insurrection just by expressing a radical view. The radical view may be this is my government is evil and they need to be removed, but not that you're inciting other people to use violence to do that. That's all perfectly legitimate, expressively and assembly wise, and it's so it's the violence is for me the dividing line there.
Thank you, Toby. Going back to one of the points raised by Gina, Pedro, the report notes that land, environmental, and indigenous rights protests are underrepresented in assembly cases. In your opinion, is there a gap, and what opportunities exist for litigation in the inter-American system?
Yeah, thank you. I think there is an underrepresentation of those causes and constituencies at the inter-American level in the petitions and cases system. I think that when we go to other, let's say, monitoring hearings, thematic hearings, we'll find even precautionary measures in the past. We'll have additional information. I think, I mean, we are expecting a decision from the Inter-American Court. Is the case of Garcia Romero. The hearing of that case took place last year, and we expect this 2026 as the year to have a special decision that also could cover the use of force, or should cover the use of force. This is the case of a journalist, but I think that the standards that could be set up in this decision could be applied to the constitutions you are asking for. But then in the field of gaps, I would like to highlight three additional gaps that I think are partially covered in the report. The first one is stigmatization. The second one is the use of tech surveillance. And the third is a very difficult situation. I mean, we often receive reports and denounces from people that want to exercise their right to freedom of assembly, and they make allegations that the episodes of violence were simulated by placed there by, in a very deliberate way by the government or the contradictor they have. No, I think that these 3 points should be, because at the end those are like traps to the exercise of the right to freedom of assembly. I think it could be a betrayal to, minimum democratic commitments. And also it could be a shortcut to deliberation, because we haven't, discussed this, and I think it's an assumption of this panel, but the right to freedom of assembly plays a role in the liberation process of a democratic society. No, so it's a way to interact that is complementary to other ways of participation, such as the parliament. So if we, for example, have normalized, and I think that we is being unfortunately normalized, a way to denigrate from the government the people that do participate in a demonstration, that is bad for the deliberation because it also includes a chilling effect. No one wants to be labeled as a bad actor, a poisoned actor for the society. I mean, and if that is said through the voice of the public officials, I think that damage severely the grounds for democratic deliberation. So these three would be, and of course, I think the also the path that, for example, indigenous communities, environmental activists, the path they have to cross through, at least to have some kind of institutionality that at least listen to their claims. It's a longer path, and that it's something that has to be fixed.
Great. Thank you so much, Pedro. On the same question, turning to you, Dawn, about the African context, do you think land and environmental rights protests are underrepresented in assembly cases in that African context? And do opportunities exist for litigation there?
Yes, I think so very much. I echo what what Pedro says first, and environmental cases, especially affecting indigenous communities. So the few that we do have become iconic and everybody follows them and everybody cites them. But then that masks the fact that there are many more communities that are suffering that do not yet get access to courts, especially when you go beyond the national level to the regional, the continental mechanisms. So I think that is an issue by itself, that the cases are too few. Then secondly, we tend to get then overwhelmed when we're doing the litigation with the core rights, like the right to the land itself, the right to a resource, the right not to be evicted, the right to free, fair, and informed consent, and so on. And then the assembly issues then tend to get buried in all that and underlooked. So I think that it's strategy to ring fence and cite that violation as a violation itself, and then build it up, in the evidence that we then make, and then try and really build it up in the submissions, written and oral. And I think importantly, because I'm really enjoying listening to Toby and so on, and the colleagues who have worked on this specific right, as opposed to working on the whole gamut of rights, really try and see if we can get participation of experts, of Amici, Curia, and other third-party interveners who will come to address this particular issue, as opposed to the issue of the right to life, right to dignity, right to land, and so on. So maybe that's the one thing that can help us within the existing casework to progressively build the jurisprudence and the focus on this right. Thanks.
Thank you, Dawn. We can then turn to some of the questions from the audience. So any of you feel free to chime in on those. One question is, how can civil society effectively reclaim local assemblies and consultation processes when they are systematically instrumentalized by corporations behind extractive projects such as mining and hydroelectric developments? And what concrete safeguards are needed to ensure these spaces genuinely reflect community consent rather than manufactured approval?
Where did you get that question? Because it was too long and I need to
it's in the Q&A function here on Zoom. Yeah.
Okay,
yeah, it's on the Q&A. I mean, I think the problem that I think Fernando brings out is real. The power of corporations and the power of corporations then to be able to, buy or instrumentalize the police or even government at large. And then processes get misused and abused. I think there's genuine scope, at least when I look at this issue across Africa, there's genuine need for movement building and coalition building amongst human rights actors and among, right-thinking members of the public. In many instances where these kinds of developments are happening, mining, big hydro dams, and so on, they tend to happen in rural areas and sometimes in areas that are remote. And sometimes, therefore, this affects, like maybe a small section of the community. And in terms of ethnicities, maybe 2 or 3 ethnicities, which many times are minority ethnicities in the first place. So then their struggle becomes individualized and becomes their own struggle. And many times it's not linked. And the larger struggles and the larger communities do not then caught on to that. So like you support them to do their struggle there, rather than build huge national, regional, even continental solidarities and movements where every person's problem is every person's problem. So I think a big issue here is beyond the law and litigation. It's about more conscious movement building across the vast human rights community. And I think something else that we haven't touched on enough, or hasn't come out enough here, is the role of national human rights institutions, where they exist and where they choose to be active. Because NHRIs, the National Human Rights Institutions, can then be a very good intervening actor in terms of protecting the core civic rights and allowing communities and so on to assemble and to argue their issues. So I think beyond litigation, how we work with national human rights institutions, but also how we hold national human rights institutions accountable for fulfilling their mandates. Thanks.
Thank you very much, Don. There seems to be another question here in the Q&A function, generally about mandatory notification systems. Suggests that mandatory notification requirements are generally a legitimate interference with the right of peaceful assembly. Just opening this up to all of you, I was wondering to what extent do you see mandatory notification requirements feature in the relevant systems you're active in, and do you see any concerns there regarding those, any trends and so on? We would love to hear about that. Toby, if you want to go first.
Yeah, I've been mulling that one over for a little while actually, since it was first posted. Yeah, I mean, I think that's an excellent question. It is, and I mean, I think it's very well phrased as well, because it says that international human rights law has adopted the wrong starting point, because it is clear that notification is actually one of the issues which has received more treatment in the jurisprudence, and the courts and other bodies like the Human Rights Committee have largely accepted them. The position that we took in the report was to some extent whether even first of all, that we recognize, as Michael has said, that there are certain cases where the notification is impossible to comply with, for example, spontaneous assemblies, and an assembly that springs up by itself and isn't really even organized. So who would file a notification in those cases and things? But maybe there needs to be at a minimum, maybe there needs to be a bigger carve out for that. The way we approached it in the report was to ask about whether any sanction, so even if a notification regime is mandatory, whether there could be any sanctions for not complying with it, because something being mandatory and the application of sanctions for not complying with it are different things, and under what conditions and whatever, none of which has been looked at in the case law. In the case law, effectively, the notification regimes were all, or the way that they were applied or something, in each case, those were found to be illegitimate. So, the issue of what about a presumptively legitimate notification regime, which then, was fallen foul of and resulted and the assembly went on and it didn't, it's clear that the absence of notification does not invalidate an assembly. I think that's clear from the jurisprudence, certainly the position we took in the report. But let's say the assembly was allowed and then afterwards, some organizers were slapped with administrative fines. Would that be legitimate? And so we took it from the perspective of sanctions. And would that ever be legitimate? But perhaps, your slightly more radical approach, if I can describe it as such, maybe we should be questioning that. And I suppose that would be, as Gina said, we need to come together to discuss some of these difficult issues. And, maybe that is one, and so voluntary notification regimes, even with structures around them. So, reporting places, because you need to know where to notify and all that kind of stuff, but making them purely voluntary and never mandatory, so that somebody who wants to organize a demonstration on a street would likely notify if they didn't think that would pull down repression, because they do want the police to reorganize the traffic and not to disrupt beyond what's necessary and whatever. But if they didn't want to, they wouldn't have to. Maybe that is the better approach, and maybe we should be pushing for that. So thanks for that question.
Thank you, Toby. Gina, do you want to go ahead?
Yeah, no, just to say
Yeah.
that I agree that the focus is on the sanctions. I mean, the issue of notification is very tricky also, as I do understand that in some cases a notification is useful even to ensure the security of the assembly. Especially if we are talking about a protest that is talking about an issue that is sensitive, and sometimes you actually need actual concrete protection to the people who is doing the assembly. But then the issue on how those, because in some cases we have countries that are very, very, I don't know, sneaky, in the sense that they actually say that the notification is not obligatory and is not mandatory, but in reality it is. And in reality, it's just actually constraining the possibility of the right. And then the report, now that I remember, the report repeats that I can't remember now how it says, but how it's important to ensure the security and so on, and then just the open just this wider possibility for governments to restrict certain assemblies when there is not possibility to secure or to ensure the security. But in some cases, that is just that the governments are not doing the work that they can do to ensure the security without needing to force the organizers or the people to actually change the date or the route or whatever. So this is like the nuances on the shade of grays that you have when you are talking about what happens with what is in reality the facilitation of a protest in this specific case. But then I agree with Toby that the issue of sanctions and what happened after, what happened when notification is not ensured, which is need to be taken into account. And again, I'll go back in the issue of proportionality. So if a protest, for example, is not notified and then is dispersed and is this with excessive use of force and so on, that is a disproportionate approach on a protest only for not fulfilling the notification that at the end becomes an authorization.
May
One-
I?
Yes, Pedro, please.
Just because I think we are getting into one of those discussions that are, in a way, dilemmas of human rights and free expression and freedom of assembly. In my view, I mean, notification is desirable when possible and exclusively for facilitating the right to protest. And I want to clarify some of the concepts that I just mentioned. No, desirable because, I mean, sometimes the right of freedom of assembly, it's a reaction to something that suddenly happened. Even in strong democratic countries, there could be circumstances that a group of people would like to react publicly that go in a rhythm that is different than the bureaucratic rhythm. and I think that that expression should be protected. No, the unexpected something and the right to react collectively to that. So I think that that's why I use the word desirable. Then, when possible, I mean, I monitor a group of countries where it's not possible to notify and receive a response with a human rights approach. We have authoritarian regimes. I wouldn't ask a group of people as a mandatory requirement for freedom of assembly to send a notification or to receive a notification from an authoritarian government. I mean, I think that in those contexts is not possible at all. And then facilitation purposes. I think that if the state or the government uh, uh, receives that information to welcome to hug the right to freedom of assembly and to set up and display positive measures to protect the exercise of that right, that's our dream. But if the notification is used, for example, to prepare surveillance, to prepare simulations of violence, to prepare propaganda, I think that that's not the purpose of the notification. So I think, and all of this requires democratic institutions, checks and balances, a lot of transparency. So it's not for me, it's not the dilemma of notification, not notification. I mean, it should be chained. Different links of the chain to be part of this coherence. And sorry if I took longer than this.
No.
Can I just make a very quick comment on that? So, I think one of the points we made in the report is that you should have access to rapid redress mechanisms before assemblies in case you have problems with, illegitimate rejection of, control through notification regimes or whatever. So I think that's also part of the picture. And I agree with you, Pedro, about this wider thing. This question of how to balance what are the proper human rights standards and then the risk of abuse in bad countries. It's something that I've struggled with for 25 years or so. For example, in the area of defamation, you do need a defamation law because people's reputation does need to be protected. But in a repressive country, undoubtedly, the defamation law, first of all, is not going to be correct in its standards, and secondly, it's going to be applied abusively. Doesn't mean that you don't call for defamation laws. And, you have to fix those other problems in the repressive country. So it's, I think it's a challenge to manage that repressive context. Bad things are going to happen in repressive contexts because they are repressive and they don't care about human rights and they hate human rights, so they're repressing human rights. But in setting the correct standards, you have to a little bit step outside of that. But of course, to the extent possible, design those standards so that they're non-abusable, if you will, limitedly abusable, but very difficult, including for defamation and other kinds of restrictions on freedom of expression. So difficult challenge.
Great. Thank you very much, Toby. As we are running out of time and approaching the end of the webinar today, obviously there's a lot more to discuss, and this is only a little sample of all the interesting issues at stake. But I would like to thank you all so much for joining us today, and especially to our distinguished speakers. Each one of you has contributed so much from your respective roles to safeguarding the right to freedom of assembly, and thank you so much for that. We invite you all not only to check out our report on litigation gaps and opportunities at the international and regional levels, which is now available on our website, but also to explore the amazing resources our speakers have spoken about in this discussion. So thank you all for that. We would also like to thank all of our wonderful colleagues who worked very hard on the public version of this report. So starting with Toby, Angelita, Sofia Jaramillo, Laura Notes, Esper, and Sahar Fatima. Thank you all so much. And also to all our colleagues here who have helped us organize today's webinar, including Ezihe Chikere and our wonderful comms and operations team. Thank you for putting this together. So thank you all so much for joining us today, and we wish you a wonderful day.
And thanks also to you, Nifel.